successful in the tender. The notice party, there was a notice party to the action, which was the successful company. And interestingly enough, the tender was for the provision of air ambulance services. And the case hinged on the definition of tender services within the request for tender document, and whether the tender was restricted to the transportation of just patients, so just people, intact, if you like, human beings, or also included the transport of organs and organ removal teams. Now, not playing organs now. Now, in the end, the court found in favour of the HSE and agreed with their interpretation of the of tender services. But in the subsequent judgment, there were various other issues that had to be decided even after the substantive issue was decided. And Mr. Justice Toomey went into a lot of detail in relation to the requirement to discuss mediation. He had, on the first day of the hearing, actually asked both parties what efforts they had made in relation to mediation. So he found and gave quite a detailed statement on the fact that everyone litigating in Ireland, but in particular a state agency, should consider mediation in every dispute in which it is involved. And he set out 5 reasons for this. Number 1, quoting a previous Supreme Court judgment, he found that litigation is the most expensive way imaginable to resolve disputes. I think we're probably all fairly clear on that. He also found that, or pointed out that in the case of litigation involving the state, it is at the end of the day the taxpayer who will be footing the bill. And while he didn't refer to this, he has probably since read the most recent report of the State Claims Agency, which has put the cost of outstanding claims against the state in 2022 at €4.957 billion, which as a taxpayer is quite a big sum. So he was certainly making that point. He also found that the costs are often not proportional to the value or the importance of the dispute. Now, he didn't apply that in this particular case because, again, taxpayers' money was concerned, and the aim of the HSE was to get the best bang for their buck in terms of the tender services. He further made an interesting point, which is, and he quoted Ms. Justice Murphy here, who said that the state is the most frequent litigant appearing before our courts. And he pointed out that if more cases involving the state were resolved in mediation, this would ease pressure on court resources and actually free up court time and make access to justice more attainable for ordinary citizens, rather than having the courts blocked up, if you like, by cases involving the state. Finally, he pointed out that state agencies do not have the same financial incentives as individual or ordinary litigants, if you like, to pursue mediation. So if you or I, or more specifically, your corporate or your personal clients are going to litigation, you will be advising them about the risk to their wallets if they lose. But of course, because no one individual in the particular state agency or in the instrument of state will be reaching into their wallets for this cost, the same incentive isn't there. Therefore, there is a greater onus, if you like, on state agencies to consider mediation before litigation. So a judgment worth reading if you get the chance, and is available on courts.ie.
So just jumping in there, Sabina, it looks like clearly the main drivers are financial, but what does this mean in practice for solicitors?
So in practice, and I'm sure there are some amongst our venerable audience who are or have been advising state agencies and state bodies in relation to litigation. I think this has ramped up your obligations, if you like, to encourage your clients to consider mediation before litigating. It probably also indicates that judges are more likely to ask, as Mr. Justice Toomey did on the first day, why are you here? Why haven't you, or what efforts have you made to try to get this through mediation? Of course, the judge has the option then to make a Section 16 invitation to mediation under the order, which can carry cost penalties. Equally, if you are acting for a litigant who is on the other side of a case involving the state, and they want to get into mediation, but maybe the state agency is dragging its heels, this will certainly give you some, I don't want to use the word ammunition in this collaborative space, but some reasoning, let's say, to maybe even make an application, or certainly to make contact with your opposite number and say, look, I think mediation might be a good idea, and I think the court is likely to think so too. So it all comes back to you as solicitors, as legal advisors, and as mediators, but particularly as solicitors, your conversations with your clients around the different options that they have and which are going to be best for them to take.
Excellent. Thank you. That leads us nicely into our segment on practice and getting clients, or as you mentioned, encouraging clients to consider mediation is a skill. It's also a legal requirement, and Section 14 of your Act over there. But it's also a little bit scientific, and I'll come on to that, our science corner, in a moment. But we're going to run a little poll just in the first instance, just to see actually how often do you advise clients in relation to mediation? Never, once a week, once a month, or any other? Okay.
Interesting. Okay, we'll give you another couple of minutes, and I just need to admit somebody. There we go. Okay, so the winner at the moment, and I'll leave the poll open for another couple of seconds. The winner at the moment is once per month, which is interesting, followed in joint second place by never and other. So I'm intrigued about the other, and we might come back to that if we have a chance at the end to see if someone is actually advising their clients in relation to mediation more than once a week, which would be very interesting. But anyway, back over to you, Alan.
Yeah, all right. So getting people into mediation, particularly if you're thinking about clients that are already coming to you feeling anxious, concerned, the idea of getting into something new, unfamiliar, will be, so I'm just trying to get rid of this poll. It keeps on popping up.
Sorry, I've closed it down.
Okay, thanks. Will be challenging, and that's what the research says. Now, there is a professor, Liz Stokoe. She is a social scientist and the professor of social interaction at London School of Economics. And she studies conversations in a real granular level, just to try and make sense of what people are saying, and then infer meaning into what they may not be saying. And she looks at patterns in conversations, looks at massive data sets, and then reasons up from there. One of Liz's earlier projects, she studied hundreds of recorded phone calls between clients phoning into a mediation service for the first time, and mediators then receiving those calls and then trying to convert parties into mediation. And one of the interesting discoveries that Liz found, in almost 70% of those cases, the parties were turned off the idea of mediation and chose not to pursue it further. It transpired that there were certain words or certain phrases that led parties not to take matters further. And on the other side, there were certain words and phrases that were more persuasive in attracting parties to the mediation process. So framing is critically important when you are trying to advise clients in relation to mediation. For example, it can be difficult. Mediation can be a difficult process. It can involve, high emotions. It can involve a whole host of other matters, other things that might be unsettling. And those aren't helpful. Framing mediation as an opportunity to have a really productive conversation, managed by a skilled, independent third party called a mediator, is a much better way of kind of framing the conversation. Talking about how the mediator will be managing the process, but actually you, the client, will be in complete control of the outcome. And talking about how the mediator will help you to problem solve, generate options, negotiate effectively. One of the great things is it's a voluntary process. If none of this is working for you at any point during the mediation, you are free to withdraw. And so, again, framing it up in that way, making it more attractive for the client to start thinking a little bit more about their options and maybe becoming curious about the mediation process, talking about how it's also a golden opportunity. My favorite phrase is actually, it's a golden opportunity to mitigate risk of a decision going against you should you end up in court. It's an entirely confidential process. So you can, share information, you can talk about ideas, you can make proposals, and none of that will leave the mediation room. So, framing it up in a positive way, in an active way, so that making it interesting, attractive, and you're wanting to try and stimulate questions and curiosity from your clients. And of course, topping and tailing it with, whilst success is never guaranteed in mediation, 80% of cases typically end up in settlement that go to mediation. So again, there's a little carrot there. And but it's important to frame the conversation.
So again, from a practitioner's perspective, then what are the takeaways from this, or what can you do? Because I know as lawyers, we have our defaults in terms of language, and certainly I know I often give out about the Law Society's precedent letter because you need a degree in law to actually understand it. So what would you recommend practitioners do who are regularly engaging with clients and trying to entice them into the mediation process?
Yeah, so, just putting myself in, when I'm mediating, for example, having done it for years and years and years, I still have a template of points that I want to get across right at the very outset of the mediation. Even though I know it in my sleep, I still want to make sure that I frame things in a positive way. So I'll have a checklist. I'll maybe, write it out in a way that's natural and comfortable for me, and I may say it out loud, get reaction of a colleague, for example. How does this come across? How does this sound? And then I use that template then in every mediation. So if you're a solicitor advising a client, you could do exactly the same thing. What are you going to say? How are you going to frame it? What are the important things that you need to get across? What are some of the questions that you could ask? So there are lots of things that you could do, but just preparation is really critical here.
Brilliant. Okay, and now we're going to kind of dig a little bit deeper into that point and the difference between what we might do as litigators and what we might do as mediation advocates. And Aled is just going to tee this up for us. We now have a little bit of input from one of the absolute legends of mediation and indeed other work in Ireland, Turlough O'Donnell, Senior Counsel, who many of you will be familiar with, who is, I mean, certainly definitely one of the most thoughtful and skilled mediators I've come across. And in this short clip, he's just going to talk a little bit about what lawyers must understand about litigation and mediation. Roll it there, Roisin.
These are very different skills from those lawyers would use to guide a client through adversarial court proceedings then. To what extent is a whole new set of learnings and skills and practice required by lawyers to really become effective mediation lawyers?
I think the fundamental thing that lawyers should do is understand that the two systems are totally different and not to confuse each system. And they should understand the purpose of mediation and the purpose, on the other hand, of adversarial litigation. The purpose of adversarial litigation is to seek to win the dispute and convince the trial judge or the arbitrator that you are right and the other person is wrong. The adversarial system is a matter of right and wrong. Mediation is a matter not of right and wrong, but a matter of win-win, both sides believing that the dispute has been resolved satisfactorily. If you understand that as a lawyer, if you understand that these are two different situations, two different systems rather, then I think you won't go wrong.
There we go.
Excellent.
Go ahead.
Hold on, sorry. I'm just getting back to my screen sharing. Apologies for the...
He's also one of the easiest people to listen to. I think there's something about his voice and his manner. And I've seen it actually in a mediation. He just has a very calming influence on parties, you know. And I think, you know, in effect, what he's saying there, and those of you who have dipped a toe into the waters of mediation or mediation advocacy will be beginning to see that it's almost like you're changing from a Windows to a Mac operating system in terms of your how you're approaching your clients and how you're approaching the process. And in terms of how you can do this in practice, there's a couple of different things. And I mean, quite practically, you know, Turlough has said there that, you know, in litigation, it's about right and wrong. The focus in litigation also tends to be on the past. So, you know, who did what? How did we interpret the tender document? You know, how did we calculate the value of the services we were providing? Who said what to whom? Of course, a lot of the time, who influenced whom to make which part would bequest in their will. Whereas in mediation, although, you know, we're working within the space of what happened in the past, the focus is on the future. And, you know, how are we going to solve this? How are we going to resolve this so that the HSE can get on, that the organs can be transported, that, you know, the parties can get back to work, to their business? So even that slight shift from focusing on the past to focusing on the future. The real difficult one is the mindset shift, I think, and I know it took me years, even as a not particularly enthusiastic litigator, not that I was really a litigator, but to make that shift from kind of making legal arguments to problem solving. You know, rather than focusing on sort of, well, my client is right and is entitled to this because of this, to saying, well, I know my client and I think my client is entitled to this and you think your client is entitled to that, but how are we actually going to solve this problem, or, you know, redistribute these resources, or, you know, end this business relationship in such a way that neither one of us is going to be damaged? And then, of course, you have the skills, your toolbox or your cart full of different skills. And I'm going to just ask you, Aled, you're the skills meister in this outfit. Tell us a little bit more about those skills.
Yeah, I mean, you've got a whole bunch of different categories of skills. You know, you've got process management skills, managing the different stages of the mediation process and, you know, assisting your client through those. You've got managing communication between you and the client, between your client and the mediator, between you and the other side. You've got the interpersonal skills. You know, how do you handle a strong emotional reaction? How do you assist your client when, you know, they dig their heels in, or they feel like they can't go any further, where there's impasse in the communication? Of course, you've got a whole host of different skills within the negotiation process. You've got skills like you know, just the questioning, the different range of questions that you could be utilizing at different parts of the process. You've got open questions to try and tease out information. You've got other reality testing questions once you're getting closer to generating options. When you're trying to get under the surface of the dispute and trying to tap into some of the motivators to settlement. You're going to be trying to, you know, understand what the interests that are underlying the positions. So there are a whole multitude of different skills that are really critical to help move through the process. And as you've said, Sabina, the real challenge is if you think about your mindset is the operating system and your skills is the software. If you're running an old, out-of-date operating system, but you've got the latest version of I don't know, Microsoft Word, it's going to be buggy, it's going to crash all the time. So you have to make sure that your mindset, you're in that right mindset, that collaborative frame, forward-looking, not looking through the rearview mirror, so that then you can be genuinely curious to then promote those open questions, and you can avoid getting caught in other outdated traps. So the skills are many and vast, but it flows from the mindset.
And to just kind of round that off, the difference between these skills and your other lawyering skills, as you say, is, I suppose, as mediation has developed in the last few decades, a lot more work and research and thinking and setting of standards, believe it or not, has been done around the skills of lawyers in mediation. And various different bodies now offer mediation advocacy qualifications and assessments and distinct designations. Because people working in the space, lawyers working in the space, have recognized how different that kind of work is to your adversarial litigation work. So we do have a question I want to answer, and we have about 3 minutes left for questions, in case you all have your coffee machines programmed to deliver your first Americano at 8:30 on the dot, like I do. So we have a question from Bridget in relation to, does discovery of documents in advance of mediation assist, or can you do mediation without them? No, I'm going to answer that in two ways. So first of all, documents, yes, as a mediator, you will definitely want documentation in advance, because obviously the more information you have as a mediator, the better. You will always know as a mediator that there's the information that's in the documents, and then there's the information that you'll get from the parties. And, you know, while you're going to hope that the two overlap, there tends to be a lot more information that you'll get from the parties than is visible in the documents. In terms of discovery itself, if there is a reluctance, let's say, to exchange or disclose documents, and there could be a benefit to having gone through that process before mediation and I think certainly in more complex cases, that would be the case. One area in which it arises, which we've been kind of discussing a fair bit recently, and maybe is not directly analogous to discovery, but is where information such as expert reports and particularly medical reports are required. So you're by and large going to get little benefit from mediating medical negligence case before, for example, all the medical reports are available, because you just don't have the information that is going to give the parties the ability to make the decisions that they're going to need to make. Of course, the difficulty is that you can't order discovery in the context of mediation because it's an informal process. So again, what you're going to want is a good link up between the mediator, the lawyers in particular, and the parties to ensure that if you're going to mediate, all the relevant information is available and has been shared in advance of the mediation. I hope that is a relatively quick fire answer to actually quite a complex and a very relevant question.
Yeah, super question, super answer. I was just about to say all of that myself, so I'm glad you got it there first, Sabina. All right, everyone. Look, this is our first spotlight on mediation. We intend to do more. So if you'd like to, if you thought this was useful and would like to sign up for the next one will be taking place in about a month's time, Tuesday, April 18th, 8 a.m. You can also sign up to our newsletter, which is also something new. Head on over to mediateacademy.com. Annoying little pop-up will show up and you just enter your details in there. We won't spam you. You'll just get a newsletter from us, and that's about it. And please do spread the word if you thought it was useful. Share it with your colleagues, pals, and anyone you think might find this webinar useful. Thank you all for turning up. Have an awesome day.
For me too. Have a great day, great week.
And we'll see you next time.
Take care.